In a tense committee hearing, Mr. Moolenaar and Mr. Nadler led a sharp debate on a bill concerning violence by illegal aliens. Lawmakers grappled with the implications of proposed immigration law changes, with accusations flying over the effectiveness and potential unintended consequences for vulnerable populations. The core tension revolved around national security concerns versus the protection of individual rights and humanitarian considerations.
To release 5 million illegal aliens into the United States. Now, when you combine that with nearly 2 million gotaways who've evaded apprehension entirely and who've escaped into the United States, the illegal alien population has grown by nearly 7 million. Those are the training materials required for all of ICE's enforcement personnel nationwide. Instead of making clear that ICE officers should carry out their duties to remove criminal aliens from American streets, DHS instructs ICE officers to develop a, quote, full profile of a criminal alien before deciding whether to arrest someone who's in the country illegally. According to local officials, a Guatemalan national crossed the U.S.-Mexico border in early January, made his way to Florida shortly thereafter, and does not have an immigration court date until 2027. That's Joe Biden's immigration legacy. More unvetted aliens released into American communities, more criminal aliens on American streets, and more Americans endangered by radical, reckless policies. It seems the real war on women is perpetrated by the president's open border policies, which allow more sexual offenders, domestic violence offenders, and child abusers not only into the country, but also to remain in the country indefinitely, free from fear of deportation. American people can end this nightmare in a few months. If voters choose to fix this crisis in November, Republicans have proposed new laws that will allow the next president to secure the border and increase interior immigration enforcement beginning on day one. H.R. 7909 is just one of many of those bills. This measure, the Violence Against Women by Illegal Aliens Act, makes crystal clear that illegal aliens who commit sex offenses are inadmissible to and removable from the United States. The bill also fixes a discrepancy in current immigration law by creating a ground of inadmissibility for domestic violence to mirror the existing ground of removability for the same offenses. The bill also expands the current ground of inadmissibility for domestic violence by cross-referencing an existing statutory definition for sex offenses. Although many aliens can already be found inadmissible to and removable from the United States for certain sex offenses and domestic violence offenses, H.R. 7909 expands and clarifies the conduct for which an alien can be found removable from the country. The time is now to take seriously the danger of criminal aliens in the United States. Anything that makes it easier for adjudicators and officials to ensure a criminal alien's arrest and removal should receive overwhelming bipartisan support, particularly when it comes to sex offenses and domestic violence. I'd urge my colleagues to support the Violence Against Women by Illegal Aliens Act. It is simply common sense. I yield back the balance of my time.
Gentleman yields back. The ranking member is recognized.
Thank you, Mr. Chairman. Mr. Chairman, here we are again marking up a bill that is another attempt by the majority to scapegoat and fearmonger about immigrants. Despite its title, this bill will impact not only those who are undocumented, but also lawful permanent residents or green card holders. This bill will do nothing to secure our border or fix our broken immigration system. It does not close any gaps or fix any loopholes in the law. It is purely a messaging bill and an attempt to score cheap political points. H.R. 7909 purports to add new grounds of inadmissibility and deportability for, quote, sexual offenses, adds new grounds of inadmissibility for domestic violence and other related offenses, and expands the current ground for deportability for domestic violence. If that were where the bill stopped, it would be almost entirely redundant to current law. Let me repeat, because all of the conduct described here already constitutes a deportable offense, this bill would ensure that no additional dangerous individuals would face immigration consequences. Zero. But as has been the case in every one of the dozen or so immigration messaging bills we have considered so far, this sloppy, poorly conceived, poorly drafted legislation has far-reaching and unintended consequences. At least I hope they are unintended, because this bill includes overly broad definitions and lacks any waiver authority. It threatens to sweep in far more people than it should, including the survivors of domestic violence. Let's break down the problem. Sexual offenses and domestic violence are serious offenses, and if these bills fix some gap in current law, I would have no problem supporting this legislation. But that is not the case here. First, the sexual offenses in the inadmissibility and deportability sections of the bill are largely redundant. All serious sexual offenses are already covered under current law. Currently, an individual is rendered deportable if they are convicted of an aggravated felony, which includes rape, sexual abuse of a minor, or a crime of violence, which is defined as any, quote, offense that has as an element the use, attempted use, or threatened use of physical force against the person, close quote. In comparison, this bill would render deportable those convicted of, quote, sexual offenses, which is defined as, quote, a criminal offense that has an element involving a sexual act or sexual contact with another, close quote. These categories almost entirely overlap. Additionally, under the Immigration and Nationality Act, a non-citizen who is convicted of a crime involving moral turpitude, or a CIMT, is already subject to removal. Crimes in which there is intent to cause bodily harm have long been considered CIMTs. As such, people who are convicted of any crime where there is intent to cause bodily harm, like sexual assaults, are deportable. The inadmissibility grounds for CIMT are even broader, as one can be deemed inadmissible by either being convicted of or admitting to acts that constitute a CIMT. Again, if that were all this bill did, it would simply be a waste of our time. But even more significant concerns with this bill arise with the sections related to domestic violence. Under current law, people are deportable if they are convicted of domestic violence and other related crimes and can be deemed inadmissible if they commit the acts or are convicted of a CIMT, where the domestic violence or related offense has intent to cause bodily harm. So the crime of domestic violence is well covered by current law. However, this bill attempts to significantly expand the definition of domestic violence to include the Violence Against Women Act definition that is used for grants and funding. The current definition for domestic violence offenses under Title 18, which is what is currently used for deportability purposes, focuses on physical force. In contrast, the broader VAWA-based definition used in this bill would lead to more people being ineligible for status or subject to deportation and would sweep in a broader range of behaviors, including criminal charges where there might be any coercive actions, including economic coercion and coercive control. This will likely implicate survivors of domestic violence who have used violence in self-defense or who were accused by their abusers and were either unable to defend themselves or pled guilty to avoid having to go through the court process. The VAWA definition was never intended to be used as a criminal statute or to capture only criminal behavior. We know this because the statute specifically says it includes, quote, a pattern of any other coercive behavior committed, enabled, or solicited to gain or maintain power and control over a victim, including verbal, psychological, economic, or technological abuse that may or may not constitute criminal behavior, close quote. And you do not have to take my word for it. Nearly 180 national and local groups as part of the National Task Force to End Sexual and Domestic Violence echo these same concerns in their letter opposing this legislation. I ask unanimous consent to submit their letter for the record.
Without objection.
By layering immigration consequences onto the existing challenges of talking about domestic abuse, this legislation will almost certainly create a chilling effect in immigrant communities with regard to the reporting of crimes of domestic violence. Further, this bill attempts to create a new ground of inadmissibility for domestic violence, which does not require a conviction and does not have any of the exceptions that currently exist in the deportability grounds. Under current law, when an individual is convicted of domestic violence or stalking and therefore becomes deportable, there are exceptions if the government finds that the individual is not the primary perpetrator, was acting in self-defense, or the crime did not result in serious bodily injury. While domestic violence advocates have concerns about the effectiveness of these waivers, such waivers are not even an option in the new inadmissibility grounds under this bill, which means it would certainly lead to survivors being deemed inadmissible, given the expansive definition and no conviction requirement. That is why so many domestic violence organizations oppose this legislation. We anticipate even more will voice their opposition if this bill ever makes it to the House floor. This bill is dangerous. I wish my Republican colleagues would work with us to fix our immigration system instead of moving these pointless messaging bills and attempting to score cheap political points. I urge my colleagues to oppose this legislation, and I yield back.
Gentleman yields back without objection. Other opening statements will be included in the record. The chair recognizes the gentleman from California for the purpose of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment.
Amendment to
Without
the
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair recognizes the gentleman from California to explain the amendment.
Thank you, Mr. Chairman. This amendment more clearly cross-references the specific crimes delineated in the ground of removability for domestic violence that are not currently explicitly listed as grounds of admissibility. These crimes include stalking, child abuse, child neglect, child abandonment, and protection order violation.
Mr. Chairman, as I discussed in my opening statement, this bill is an ill-conceived attempt to look tough on immigration while actively harming the very community this legislation purports to protect. Survivors of domestic violence are often counter-accused by their abusers and will often plead guilty to avoid court or jail time. Nearly 180 national and local groups that advocate for survivors of sexual and domestic violence have come out against this bill because it fails to protect the people who fall into that scenario. Without making these important distinctions between victims and perpetrators, this bill strips important protections from survivors of domestic violence that exist in current law, opening them up to the risk of deportation. But I should not be too surprised. Scapegoating immigrants and attempting to weaponize the crime of domestic violence is a time-honored tradition by Republicans. This amendment also adds some important waivers. First, for crimes involving moral turpitude, there is a waiver available in current law if the individual can meet very strict criteria. Given that sexual crimes, domestic violence, and stalking are all crimes involving moral turpitude, having the same waiver as an option for these newly specified grounds simply makes sense. It will ensure we have the flexibility to stop survivors from being swept in. And then finally, under current law, a conviction for domestic violence or stalking has specific and important options for waivers for survivors, allowing the government to waive a conviction if certain criteria are met, including showing that the individual is not the primary perpetrator and that the crime was committed in self-defense. Unfortunately, the majority is attempting to add a new inadmissibility ground, but they do not even require a conviction or include any waivers. As it is, domestic violence survivors say these waivers are not as strong as they could be, but not to include them at all shows a shocking lack of empathy for survivors of domestic violence. This amendment follows the lead of the advocates for survivors of domestic violence to fix some of the many, many problems with this bill. I urge my colleagues to accept the amendment, and I yield back.
The gentleman yields back. The gentleman from California is recognized.
Mr. Chairman, I respectfully disagree completely with the ranking member. Let's start with the fact that under existing grounds of inadmissibility, an alien may already be found inadmissible for domestic violence offenses if those crimes qualify as a crime involving moral turpitude or aggravated felony. And guess what? For those crimes and grounds of inadmissibility, there are no explicit exceptions like the one proposed by this amendment. So while there's a similar exception for the domestic violent grounds of removability, keep in mind who those grounds apply to. Aliens here legally. Grounds of inadmissibility apply to aliens in the country illegally. No such exceptions necessary. It would expand the exceptions for illegal aliens. The claims that this is somehow unnecessary are ludicrous, considering our recent experience with this massive influx of very poorly vetted illegals released into our country by the administration. Take, for example, the fact that under current immigration law, there's no explicit ground of inadmissibility for illegal aliens who commit domestic violence offenses, despite a ground for removability for aliens who commit such offenses. I mean, I can go through the long list of exceptions that we have debated over and over again in this committee with respect to a variety of bills that Republicans have put forward and passed to protect the American people from this scourge. But I think I'll simply refer to those by reference and yield back the balance.
The debate concluded with deep divisions, reflecting the fundamental disagreement on how to address immigration enforcement, with Mr. Moolenaar pushing for stricter measures and Mr. Nadler highlighting potential harm to domestic violence survivors. The committee's vote underscored the politicized nature of the issue. The future of immigration policy remains fraught with unresolved conflict.